Welcome everyone, let's just jump right into it. Today we're diving into a detailed explainer on navigating what can often feel like a massive bureaucratic maze, the Land Acquisition Act of 1894. Now, if you manage large-scale road projects or major infrastructure, you already know the drill. Acquiring land is exactly where the vast majority of delays happen. But rather than looking at this historic 1894 statute as just some frustrating hurdle, we're going to flip the script. We're going to treat it as a rigid engineering blueprint. If you really understand this precise statutory flow, you'll absolutely keep your projects compliant and completely on schedule.
So here's our statutory blueprint for today. We're going to cover 6 key areas. First, preliminary investigation and objections. Second, formal declaration of acquisition. Third, land measurement and notice. Fourth, the collector's award timeline. Fifth, determining fair market compensation. And finally, number 6, taking possession and payment. Let's get moving.
All right, step 1, preliminary investigation and objections.
Kicking things off under Section 4 of the Act, a formal notification gets published in the Official Gazette. Now, this is the literal legal trigger. It's what allows government officers and project staff to lawfully step foot onto private property to survey, dig, bore, and map out boundaries. But here's the thing. From an audit compliance perspective, federal government auditors are incredibly strict about this part. Your design and drawings have to be completely comprehensive right out of the gate. Plus, your project director or consultant absolutely has to coordinate directly with the land acquisition collector, the LAC, to demarcate the alignment. You literally can't just survey blindly out there. It requires a totally synchronized effort.
And speaking of audits, here is a major gotcha we pulled directly from the Consolidated Federal Audit Report. It explicitly states that to ensure accurate acquisition of your required strip of land, permanent survey marks, which are locally known as pucca burges, must be fixed. If you try to skip this physical, on-the-ground marking, well, you're not just cutting corners, you are risking severe audit compliance failures later on that can totally stall your funding. Seriously, don't skip it.
So once that Section 4 notification hits, the clock immediately starts ticking for the public. Under Section 5A, any interested person has exactly 30 days to object to the acquisition in writing to the collector. The collector then has to give them a legitimate opportunity to be heard. This is a really critical statutory right. Only after the collector submits a formal report on these objections can the commissioner actually make a final, binding decision to proceed.
Moving right along to Step 2, formal declaration of acquisition.
Okay, the crucial turning point here is Section 6. After reviewing those Section 5A reports we just talked about, if the commissioner is satisfied, they sign a formal declaration stating that the land is indeed required for a public purpose. And listen, this isn't just some routine administrative memo. The statute specifically dictates that this declaration serves as conclusive evidence that the land is needed. It legally locks in the government's intent, giving the green light for the project to advance to the physical measurement phase.
That brings us to Step 3. Land measurement and notice.
Now, Sections 8 and 9 lay out a very strict procedure. First up, under Section 8, the land must be physically marked out, that is, if it wasn't already fully handled back in Section 4. Then, it has to be meticulously measured and a plan needs to be drawn up. Once those exact dimensions are locked in, Section 9 triggers a mandatory public notice. Basically, this notice tells all interested parties that the government formally intends to take possession, and crucially, it gives them at least 15 days to officially state their compensation claims and lay out their respective interests in the land.
To do this right, officers have to use standard measurement books to obsessively record the length, breadth, depth, and total area. You absolutely need this airtight mathematical record. Why? Because you want zero discrepancies or legal challenges down the line regarding the actual volume of land you're taking. It has to be bulletproof.
Let's shift gears to Step 4, the collector's award timeline.
I really want you to pay close attention to the tick-tock of the legal clock on this one. Section 11B of the Act mandates that this entire process of acquisition has to be completed within a strict 6-month window. And that countdown, it starts all the way back on the date of that initial Section 4 notification. You literally have 6 months to survey, hear objections, declare, measure, give notice, and finalize the award.
So what happens if a project manager or collector fumbles this timeline? Well, it triggers some massive compliance traps. The statute explicitly says that if the award isn't wrapped up in those 6 months, the collector has to formally explain the delay within the award itself. And if that excuse isn't satisfactory, they can actually be held personally responsible, which can lead straight to formal disciplinary proceedings. On top of that, audit compliance demands strict adherence to current Secretariat instructions regarding financial limits when these awards get finalized. Bottom line, the law really does not tolerate bureaucratic foot-dragging when private land is tied up.
All right, up next is Step 5, determining fair market compensation.
The guidelines the collector has to follow here are remarkably rigid, but they're split cleanly. Under Section 23, they are required to look at the market value at the time of the initial Section 4 notification. They also have to factor in real damages, things like severed land, lost standing crops, and reasonable expenses for forced relocation. But then you have Section 24. Under Section 24, they are legally barred from considering things like the owner's reluctance to sell or how urgently the project needs the land or, and this is a big one, any future increase in land value that's going to happen because you're building a new road. It is a highly objective, entirely backward-looking valuation.
Now, what is absolutely crucial to bake into your project budget is this specific figure right here, 15%. Under Section 23, subsection 2, the court mandates a 15% surcharge added straight on top of that calculated market value. Let's be clear, this is not a bonus. It is a strict statutory requirement to compensate for the compulsory nature of acquiring private land for a public purpose. You have to account for it.
Finally, we reach Step 6, taking possession and payment.
How you take possession essentially dictates your whole project schedule. So under the standard route, which is Section 16, you have to sit tight and wait until the collector makes their final award under Section 11 before you can even touch the land. But for urgent infrastructure, like major road projects, Section 17 is an absolute game changer. It allows the collector to take possession after just 15 days from the Section 9 notice expire. That applies even if the final award hasn't been completely calculated yet. As long as the estimated cost has been deposited, it's a huge fast track.
But beware of the trap hiding in Section 34. If compensation isn't paid or deposited before you take physical possession of that land, the government gets penalized. You'll be forced to pay a 6% simple interest rate on that delayed payment, running from the exact moment you take possession until the bill is finally settled.
Here's the payoff. If you follow this blueprint correctly, if you respect those timelines, coordinate the surveys, actually set your puckaborges in the ground, and deposit the funds on time, your reward is the ultimate statutory prize. Just like the Act says, the land will vest absolutely in the government, free from all encumbrances. That means no legal holds, no lingering disputes, just a totally clear, legally sound path for your construction crews to finally start building.
So that leaves us with a pretty critical question to consider about how we actually manage these massive infrastructure projects. If a single missed 15-day notice or just one absent physical survey mark can bring a multi-million-dollar road project to a complete, grinding halt, is your team truly treating the Land Acquisition Act of 1894 as the rigid engineering blueprint it actually is? Or are you just treating it as annoying administrative paperwork? Mastering the concepts in this explainer is honestly your first real step to ensuring your projects stay on track. Thanks for joining me.